This was a catastrophic betrayal of trust.
Guilty. That's the word for a now disgraced social worker who was caught sexually assaulting a 13-year-old boy she'd been assigned to counsel.
Yeah, Payton Shires has a death sentence if she's required to register as a sexual offender.
What's more, the boy's mother found out about the assaults through texts, photos, and videos on the teenager's phone.
You would be appalled at how often we see a personality disorder with the abusers. In other words, they are above the law. They will not get caught.
Things take yet another turn when the counselor shows up at the boy's home armed with a gun.
She's already being charged with sexual assault of a minor, and now she takes a firearm to the parent's home. I think that really reveals her desperation. She got caught.
We're taking a deep dive into the case so far and a look ahead at what's next for the boy's family.
So I think this is a really solid case against Shire's employer, and this is easily a seven-figure case.
Let's begin with a Law&Crime legal alert. Google Incognito tracked users' browsing data without their knowledge. Now Mass Tort Alliance, one of our legal sponsors, is helping users to file for compensation due to Google users' privacy issues through their Incognito browser. So if you've used Google Incognito anytime since 2016, you can start your claim in less than 10 questions at incognitoclaims.com/LCnews. This is the story of 24-year-old Payton Shires, who is now up against a nearly 3-decade-long prison sentence.
This is a social worker who is supposed to be looking out for the best interest of a 13-year-old boy during a traumatic time for him. And what does she do? She manipulates him, violates his trust, and allegedly sexually abuses him. Doesn't get any worse than this.
That's criminal defense attorney Brian Claypool, who specializes in sex abuse cases.
When you have a female with a young boy, sometimes in the mind of the female, like they're thinking, hey, this isn't that bad. This isn't wrong. Boys want to be with girls. So I'm not really doing anything out of the ordinary. In fact, maybe I'm even helping this young man move along with his sexual development.
The case takes us back to June 2023, when Shires was assigned to counsel a 13-year-old boy in Columbus, Ohio. The boy allegedly had behavioral issues at school, and his parents brought him to the National Youth Advocate Program for help. That's when Shires first connected with the boy, and from there, the interactions quickly grew nefarious. By fall 2023, the boy's mother had become suspicious and eventually found messages on his phone from Shires. In the texts, Shires asked the boy whether his mother had found any photos or videos or if they'd been deleted. When police took a closer look, they found those photos and videos showing explicit images of Shires and the boy.
Well, a lot of these sexual abuse cases involving minors aren't figured out, and they are not prosecuted without some tangible, credible, reliable, corroborating evidence. We always hear the word corroborate. You really need that in a sexual abuse case involving a minor. Why? Because prosecutors often look at a young person, 9, 10, 11, 12, 13 years old, and they say that that person may not be as reliable, right? Their memory may not be as sharp, and they may not be able to hold out on the stand, right? Are you going to prosecute a case against an alleged child molester with a 13-year-old who's got to get up on the stand in front of jurors in a courtroom and tell the story? So oftentimes prosecutors are reluctant to go forward with the prosecutions of the abuse of minors. But here you have additional corroborating evidence. I mean, I had a case a couple of years ago with a 15-year-old girl attending a private Catholic school here in the Los Angeles area, and we had the same thing happen. Father finds text messages from a female teacher. So this is a female teacher with a female student, and I have to tell you, the text message exchange between the 15-year-old girl and the female teacher was the basis of the entire case. I read through a litany, like a booklet of text messages between the two, and that sealed the prosecution of that female teacher.
What's interesting to me in this case, you spoke about corroborating evidence, and Payton Shires had sent this boy text messages. So we have the texts, and then additionally, there's allegedly video or photos of them in these sexual positions. Why would she leave all this evidence out there? Would she think that she's just going to get away with it?
Yeah, great question. So I've done a lot of sexual abuse cases involving minors, and you would be appalled at how often we see a personality disorder with the abusers. In other words, they are above the law. They will not get caught. And for example, here, when you have a female with a young boy, sometimes in the mind of the female, like they're thinking, hey, this isn't that bad. This isn't wrong. Boys want to be with girls. So I'm not really doing anything out of the ordinary. In fact, maybe I'm even helping this young man move along with his sexual development. So I feel like it's a borderline personality disorder that a lot of these abusers have. And by the way, I've been involved in cases where the abuser uh, abuses multiple victims. I had a case recently against the city of Santa Monica where a man volunteered at a police activities league, a nonprofit with after school kids, and he ended up abusing young boys and some young women for the span of 10 to 15 years. This went on and on. And he dressed up like a police officer, pretended to be a cop, did what this woman did here, would take the kids out to eat, would buy them gifts, grooming, and it went on for years. So you could ask yourself too, what's this guy thinking? How does he think he's not going to get caught? And I think that's what happened here. But one thing that's important in these abuse cases involving minors is the grooming process. So if you're a parent watching this, you need to be paying attention to your child interacting with a social worker, with a therapist, with a teacher, with a doctor, with a priest. You've got to pay close attention to that relationship because oftentimes you will see what's called grooming because these abusers have to build a trust level with the minor before the abuse takes place. And that's how they do it, buying them gifts, buying them clothes, buying them tennis shoes. And that's where parents can try to preempt this and then do what the young man's mom did here. Look at your phone and see if there's anything happening here, which she did find that out.
After the boy's mother contacted police, they set up a three-way call where Shires admitted to the sexual assaults. Shires spoke on the phone with the boy's mother as police secretly listened in to her confession. That led to her arrest in October 2023 and initial charges of sexual contact with a minor. Shires was released on $50,000 bond, but that's not where the story ends. There's multiple facets to this case because there was this alleged relationship happening for some time, but then after Payton Shires was arrested, she was arrested again, and this is because she went to the victim's home with a gun and then was suicidal at the front door. There were hours-long standoff outside of this home. Have you ever heard of anything like this?
I've not seen a case or heard of a case where an alleged child molester would grab a deadly weapon and then go to the home of the parent of the child allegedly molested and threaten to kill herself. The reason why we don't see that often is because it's adding fuel to the fire. I mean, she's already being charged with sexual assault of a minor, and now she takes a firearm to the parent's home. I think that really reveals her desperation. She got caught, and it's what we call the art of deflection in the litigation world, where she was trying to deflect, right? And think about what she did. She was now portraying herself as the victim. "Oh my god, I'm gonna have to commit suicide if you talk about this or if you tell on me. If you cooperate with prosecutors, I might have to kill myself." I mean, think about that. That's another mental, psychotic disorder I think that she's suffering from as well.
This incident led to additional charges for Shires, including intimidation to a victim or witness and discharging a firearm, as the gun she brought to the victim's home went off. It seems to me that these two things paired together led to the plea deal. So, that corroborating evidence that we spoke of, and then these additional charges that came when she had this weapon outside of their home. Do you think that the plea deal was the correct route to take?
Yeah, given everything we're talking about, you have text messages that are confirming the sexual encounters. You have videotape. Where do you ever get videotape of a sexual encounter between an adult female and a 13-year-old boy? You hardly ever see that. So prosecutors had that in their backpack. And then you add on to that the fact that Shires ends up going to the home. It's the worst thing she could have ever done. Going to the home of the young boy with the gun and threatening to kill herself. That reach, by the way, that re-traumatized the 13-year-old. It traumatizes the parent, but that made things even worse. So that's why I believe that Shires ended up copying a plea deal now, because who knows? The further this case could have gone along, they might have found out more damaging information about Shires. Maybe they found more text messages. Maybe they found something on her phone. Maybe they found another videotape, and maybe the charges get elevated. Maybe she's looking at more jail time. So I think what her lawyers did is they cut off the bleeding. Yeah, you caught us. This was bad. Let's try to minimize the damage.
As part of the plea deal Shires made in late May, she was found guilty of 4 counts of unlawful sexual misconduct with a minor, 1 count of inducing panic with a firearm specification, and 1 count of intimidation to a victim or witness. A second intimidation charge was dropped, as was the discharging firearm charge, as investigators later determined Shires hadn't purposely fired the weapon at the boy's home. Moving forward, she has sentencing ahead of her, and she could face up to 28 years behind bars. What do you feel about that sentence? Do you think that the judge will lean toward the lengthier sentence or a lesser sentence because this is her first offense?
Yeah, I think the judge is going to lean toward a lesser sentence. I have, over the last decade, I've seen a lot of child sexual abuse cases, and I have been bitterly disappointed with the length of jail time that these molesters are given. It is staggering, especially out here in California. I mean, I had a case of a teacher at an elementary school years ago, and he was indicted on molesting 7 or 8 young girls, and he got 25 years to life. Are you serious? 25 years to life? That means he could be out on parole after about 18 years. Are you kidding me? And by the way, there were more kids that he molested. The indictment only had 7 or 8. Here, you've got, and again, I'm not minimizing what she did, but it's probably her first criminal offense, probably her first offense involving a sexual nature against a minor. The court's going to look at her job history. She's got a responsible job. She was working as a social worker. And again, you've got the mental health component too. I think that's going to have to be looked at by the judge before he issues a sentence, wouldn't you think? I mean, here you got a woman going to the boy's home with a gun, threatening to kill herself. She has some mental health issues that I think need to be flushed out before she goes to sentencing. And by the way, her lawyer, Shire's lawyer, might argue that because of the mental health issue that she had, he or she will argue for leniency. Uh, I wouldn't be surprised if Shire's lawyer has Shire's examined by a forensic psychologist, for example, to go through what's going on in her mind, why she would do this to a 13-year-old, why allow videotape, why text, why go to the home with the gun. Is there some kind of underlying mental health issue? A good criminal defense lawyer is going to delve into that and bring that to the judge at sentencing. And if her lawyer does that, then I think you're going to see a shorter sentence. I mean, we have a problem across the country with prosecuting child molesters. Like you said, we finally have corroborating evidence. Let's go forward. We don't want to rely on a 13-year-old on the stand. But more important than that, I just think across the board, across our country, these jail terms are too short for sexual abusers of minors. I wouldn't be surprised if she got a jail sentence of somewhere, between 5 and 8 years, and then she's eligible for parole after 3 or 4 years, because this is her first offense and because of perceived mental health issues. And look, the fact that she had a good job with the county as a social worker will be percolating in the mind of the judge. The judge might be thinking, should we allow this woman to be rehabilitated? I know out here in California, and especially here in LA County, our district attorney believes in rehabilitation. So shorter jail terms, let's work on rehabilitating the perpetrator to get he or she back out into society to be productive, rather than putting somebody behind bars for 25 or 28 years.
In all, Shires could face 28 and a half years behind bars. But that's not all. Another aspect of this case, too, is that she'll have to register as a tier 2 sex offender for 25 years, at least according to the reporting that I've seen. So, how would that label affect Payton Shires in the future?
Yeah, Payton Shires has a death sentence if she is required to register as a sexual offender. How in the world is she gonna go out and get a job? Think about it. Employers are required to do background checks on all of their employees, and if she tries to apply to get a job anywhere, especially a government job with a county or a city or the state or even the federal government, this is gonna pop up on her record. So I don't know how she's ever gonna be around students again. Let's talk about that. No school, no social services agency is gonna hire her to be around students. Why? Because now what she's done has put potential employers at risk in a civil forum. So whenever we go after when there's a perpetrator of a minor, we typically go after the employer in a civil court. We go after who hired her. We argue they didn't do an adequate background check. And in this case with Shires, they didn't properly supervise her. They negligently supervised her that led to her having or sexually abusing this young boy. So she has now put at risk all of her potential employers for being sued if something happens again if she is hired. The only route I could see for Shires if she somehow creates her own business, right? Becomes an entrepreneur and tries to start her own business, where there doesn't have to be any kind of copious, background check.
You spoke about civil lawsuits there, and that's something in this case that the family is moving forward with. So, the 13-year-old boy and his family has filed a civil suit against the National Youth Advocate Program. They want at least $50,000. Do you think they have a strong case?
Oh my goodness, are you kidding me? I've done a lot of these cases, and I have currently right now, I have about 7 or 8 cases against the LA County Department of Social Services, Department of Family and Social Services, the similar agency to where Payton Shires was hired, not for a, uh, a counselor abusing a child, but because these kids were in harm's way, and then they ended up tortured, killed. Then we go after the county for failing to remove those kids when they were in danger. But putting that aside, I mean, I handle a lot of sexual abuse cases, and the monetary value of these cases is in the millions. I mean, they're saying they're asking for 50,000, but if they have a good lawyer, this is easily a seven-figure case. Why? Because of what we just talked about. The county where Shires worked has an obligation to supervise her. That's an important factor. And then one of the factors that you've got to prove in these child sexual abuse cases is that the employer knew or should have known. Those are the two standards across the country. You only need to prove one or the other. The easiest way to prove it is that the county knew, right? So whatever county Shires work for, what you have to do now, the lawyers for this young man have to now request or subpoena all prior complaints that were lodged against Shires since she was hired as a social worker. That all becomes fair game. That's how you build the civil case. Was there a prior report, for example, of another patient she attended to where the young the minor child complained to her getting too close to him or any kind of complaint that puts the county where Shires worked at on notice that she might pose a risk of harm is the standard to a minor, then you've proved that the county knew that she could be a risk to this young man. The other standard that we use a lot, it's a little harder, but you can build a case is that the county that she worked for should have known that she posed a risk of harm to young minor patients. How do you prove that? Well, you take depositions, you ask questions of supervisors. Hey, how much training did you give Shires? How often would you supervise her? How often would you actually go into a session with her? Did you monitor her after hours? Did you do any reviews of her? So you build it, constructively uh, by inference, basically. But look, in this case, when you've got video, you've got the text messages, and by the way, in a civil case, the first thing you have to prove is that the abuse happened. Right? People forget about that. We're talking about how to hold the county where Shires work responsible. The first fact is was this 13-year-old abused? In all the cases I do, sometimes that's hard, right? Because you don't have what you talked about. You don't have the text messages. You don't have the video. Then you've got to prove it through the testimony of a minor. But here, uh, they have that. The 13-year-old has that. So I think this is a really solid case against Shire's employer, and this is easily a seven-figure case.
Law&Crime reached out to the NYAP for comment on Shires' arrest. They responded in part, quote, "Protecting children is everyone's responsibility. The National Youth Advocate Program is saddened by the situation involving one of our former employees and a young person served by our organization." The statement went on to say the organization is cooperating with law enforcement. Claypool says the case is unfortunately not uncommon, meaning there's important protocol employers should be following.
We should also talk about Shire's employer. Her employer needs to formally put in her employment record that she was fired. I have seen cases where teachers are, for example, teachers are accused of sexually assaulting a minor, and then that teacher ends up leaving the school, for example, and ends up percolating years later at another school, right? And then another school or another county looks to hire this person, and they look in they get the personnel file or ask the employer, and there's no notation in the file that this employee was fired, and then they get rehired somewhere else. That's putting aside the fact that if Shires is a registered sex offender, what if she tries to go get a job when she gets out of jail? What if an employer misses, right, doing a check to see if she's a registered sex offender? I've never done that hiring people in my law firm. What if an employer misses that? Well, the second tier of protection is, how does the employer of the alleged molester handle the termination? I just had a recent case with an adult victim of child sexual abuse, and it was staggering. This guy that had molested in a police report six young girls in fifth grade, they let him go. He was eventually prosecuted, but they just okay, do you want to put in your letter of resignation? They let this guy resign. But for him being convicted, he could have very well have ended up being a teacher somewhere else. So that's a really important part of this.
Even if a conviction isn't made, Claypool suggests all inappropriate behavior should be reported and documented.
So let's even hypothetically say that there wasn't evidence to convict Shires in this case. It should be noted in her file, in her personnel file, that there was a report by a 13-year-old of her allegedly sexually molesting that 13-year-old, that the county in this case did an investigation, and that they either kept her on or let her go. But what's really important for employers across this country is, if you have somebody that was accused of molesting a minor, that better be documented somewhere, so that this potential molester cannot then go to another employer, and then that future employer calls up the prior employer. Hey, what do you think of this gal? Should I, any bad information? And they're like, oh no, she resigned. So it's super important in these child sexual abuse cases that employers are responsible. They document why an employee has been fired.
For now, Shires is being held in the Greene County Jail as she awaits sentencing. She's due back in court for that on June 27th. Reporting for Law&Crime, I'm Sierra Gillespie.